What if one seemingly obscure, almost anachronistically named court case, born from the fiery crucible of a bitter and transformative political feud, a case centered around a forgotten piece of paper, a mere undelivered commission, could fundamentally and irrevocably alter the delicate balance of power within the nascent United States, thereby shaping the very trajectory and character of American democracy for centuries to come? It involved no dramatic trial replete with impassioned witness testimony in the modern sense, no infamous defendant whose name would become a household word, no sensational crime to capture the public imagination. Yet, the 1803 Supreme Court decision in Marbury v. Madison stands, upon careful historical and legal examination, as arguably one of the most profoundly important, strategically ingenious, and far-reaching rulings in the entire annals of American history. Why does this single case, emerging from such politically charged yet seemingly minor circumstances, cast such a long and defining shadow? This is the intricate story of that landmark legal and political confrontation. It is a tale woven from the threads of intense partisan maneuvering at the highest echelons of the young republic, of last-minute, almost desperate, political appointments and crucial, undelivered documents. Ultimately, however, it is the story of a brilliant, almost audacious, legal masterstroke orchestrated by one of America's greatest and most consequential jurists, Chief Justice John Marshall. Today, we endeavor to explore the fascinating, often acrimonious, political turmoil that served as its backdrop, in the uniquely ingenious, layered legal reasoning that underpinned the decision in Marbury v. Madison. This was a case that didn't just resolve a relatively minor dispute over a judicial appointment. In doing so, with breathtaking subtlety and profound long-term impact, it armed the United States Supreme Court with its most significant, most enduring, and, at times, most controversial power: the authority to review and nullify acts of the United States Congress if deemed unconstitutional, the formidable power of judicial review. Welcome to Old Around the World, where we travel back in time to bring history back to life. Our narrative begins not in a quiet courtroom, but in the superheated, politically turbulent cauldron of the late 1790s and the critical turn of the 19th century. The young American Republic, still finding its footing after the Revolution, was deeply, almost irrevocably, divided. It found itself locked in a fierce, often vitriolic, ideological battle between two nascent, yet increasingly powerful, political factions. On one side stood the Federalists, led by prominent figures such as the incumbent President John Adams and the intellectual powerhouse Alexander Hamilton. They generally favored a strong, centralized national government, a robust financial system, industrial development, and closer diplomatic and economic ties with Great Britain. Opposing them were the Democratic Republicans, championed by the charismatic Thomas Jefferson and his close ally, the astute political theorist James Madison. They advocated for a more limited federal government, an emphasis on states' rights, an agrarian-based society populated by yeoman farmers, and were ideologically more sympathetic to the ideals, if not always the methods, of revolutionary France. The presidential election of 1800, which pitted Adams against Jefferson, was one of the most bitter, acrimonious, and personally nasty campaigns in American history. It was characterized by rampant mudslinging, wild accusations, and fundamental, irreconcilable disagreements about the very soul, character, and future direction of the fledgling nation. When Thomas Jefferson ultimately emerged victorious after a contested election that was finally decided in the House of Representatives, it marked far more than just a routine change in presidential leadership. It was hailed by his fervent supporters as the Revolution of 1800, a peaceful yet profound transfer of power that signified a fundamental, almost seismic, shift away from nearly a decade of Federalist dominance towards a more populist, democratic, and decentralized vision of American government. But the Federalists, facing the imminent and unwelcome loss of both the presidency and their controlling majority in Congress, were not prepared to relinquish their hard-won influence entirely without a fight. In the final, politically charged months, weeks, and even desperate hours of John Adams's presidency, the period historically known as the lame duck session, they sought, with considerable urgency, to entrench their party's power and ideology within the one branch of the federal government they believed they could still hope to control long-term, the federal judiciary. The outgoing Federalist-controlled Congress, in a flurry of legislative activity, swiftly passed the Judiciary Act of 1801. This act significantly expanded the structure of the federal court system, creating a host of new circuit judgeships, justices of the peace, and other judicial offices. President Adams then worked diligently, almost frantically, reportedly late into the night on his very last full day in office, March 3, 1801, signing the official parchment commissions for a flurry of these newly created Federalist judicial appointments. These last-minute appointees, rushed into office in the twilight of Federalist power, would soon become known, derisively by their political opponents, as the Midnight Judges. Several key historical figures were central to this unfolding, high-stakes political and legal drama. There was John Adams, the proud and often prickly outgoing Federalist president, deeply concerned about the future of the Republic under Jeffersonian rule and determined to leave a lasting Federalist imprint on the nation's judiciary. There was Thomas Jefferson, the incoming Democratic-Republican president, equally determined to dismantle what he saw as this Federalist judicial entrenchment, viewing it as an undemocratic, last-gasp power grab designed to thwart the will of the people as expressed in the recent election. There was James Madison, Jefferson's close friend, intellectual confidant, and his chosen Secretary of State, the official who would soon be tasked with handling the leftover administrative business of the Adams administration, including, crucially, those numerous undelivered judicial commissions. And then, towering over them all in terms of his eventual impact on this specific saga and on American constitutional law, there was John Marshall. Marshall was a staunch, unwavering Federalist, a distinguished Virginian, a veteran of the Revolutionary War, and, critically, John Adams's own Secretary of State during the final months of his presidency. In that capacity, Marshall himself, amidst the rush and chaos of the administration's final days, had been responsible for overseeing the formalization of these judicial appointments, including the affixing of the Great Seal of the United States to the commissions and their subsequent delivery. However, not all commissions were delivered before Adams left office. In a move of extraordinary political foresight and enduring consequence, just weeks before ceding the presidency to Jefferson, Adams had also appointed this very same John Marshall as the new Chief Justice of the United States Supreme Court. This appointment would prove to be one of the most significant in American history. Finally, there was William Marbury, a prosperous Maryland businessman and a committed Federalist, one of the many individuals designated as Midnight Judges. His commission as a Justice of the Peace for the District of Columbia had been duly signed by President Adams and sealed by then Secretary of State Marshall, but, crucially for our story, it had not yet been physically delivered to him when Thomas Jefferson took the oath of office as the third President of the United States. When Thomas Jefferson assumed the presidency on March 4, 1801, amidst a climate of profound political change and lingering partisan bitterness, he was unequivocally determined to roll back what he and his supporters viewed as the Federalists' illegitimate, last-minute efforts to pack the federal judiciary with their own loyalists. He quickly and firmly instructed his new Secretary of State, James Madison, not to deliver any of the remaining commissions for those midnight judges that had been formally signed and sealed by President Adams, but had been left undelivered by the outgoing administration. Among these marooned documents was William Marbury's commission. William Marbury and several other similarly spurned Federalist appointees were, understandably, incensed by this executive decision. They fervently believed they were legally and constitutionally entitled to their judicial positions. Their commissions had been properly signed by the previous president and officially sealed by the Secretary of State. The appointments, in their considered view, were complete, vested, and irrevocable. The mere physical delivery of the parchment was, they argued, a purely ministerial act, a formality that could not undo the legality of the appointment itself. Denied their posts, which they saw as rightfully theirs, Marbury and three other similarly situated individuals decided to take direct legal action, thereby challenging the authority and the actions of the new Jefferson administration in a very public and potentially explosive way. Their chosen legal strategy was to petition the United States Supreme Court directly, bypassing the lower federal courts, and asking the nation's highest court to issue a writ of mandamus. This is an ancient legal term, derived from Latin, signifying a specific type of court order that compels a government official, in this particular instance, Secretary of State James Madison, to perform a specific, non-discretionary official duty that they are legally required to undertake, in this case, to physically deliver the signed and sealed commission to William Marbury. Marbury's lawyers predicated their direct appeal to the Supreme Court on a specific, and as it would turn out, highly contentious provision within the Judiciary Act of 1789. This earlier, foundational piece of legislation, passed by the very first United States Congress, contained language that appeared, at least on its face, to grant the Supreme Court the power to issue such writs of mandamus as part of its original jurisdiction, meaning the authority to hear a case for the first time, acting in a capacity similar to a trial court, rather than hearing it on appeal from a decision made by a lower court. This seemingly straightforward lawsuit, William Marbury versus James Madison, Secretary of State of the United States, presented an immediate, profound, and politically charged challenge for the United States Supreme Court, and particularly for its newly minted Chief Justice, John Marshall. The ironies of the situation were palpable and profound. Marshall, in his very recent capacity as John Adams's Secretary of State, was the very official who, through administrative oversight or the sheer press of events in the final chaotic days of the Adams administration, had failed to ensure that Marbury's commission, among others, was physically delivered. Now, as Chief Justice, he found himself in the extraordinary position of presiding over a case that stemmed directly from his own prior administrative actions or inactions. More broadly, the Supreme Court in 1801 was, by a considerable margin, the weakest and least influential of the three branches of the federal government. It possessed little of the prestige it commands today, its decisions were not always respected, and it had virtually no independent power to enforce its rulings. And it was now poised for a direct, high-stakes confrontation with a popular new president, Thomas Jefferson, and his powerful administration, who were openly, and often vocally, hostile to the Federalist-dominated judiciary in general, and to the person and political leanings of Chief Justice Marshall in particular. The stage was set for a defining moment. Chief Justice John Marshall, a man of keen intellect, profound legal insight, and considerable political astuteness, faced an enviable and acutely perilous dilemma. The Marbury v. Madison case, while ostensibly a minor dispute over a relatively low-level judicial appointment, was laden with explosive political dynamite and carried profound, far-reaching implications for the future institutional standing of the Supreme Court and the delicate, still evolving balance of power within the fledgling federal government. If Marshall and the court were to side with Marbury and issue the writ of mandamus, ordering Secretary of State James Madison to deliver the commission, the Jefferson administration, deeply resentful of the midnight judges and eager to assert its own authority, would almost certainly refuse to comply. Such open, contemptuous defiance by the executive branch would starkly expose the Supreme Court's inherent institutional weakness, its critical lack of independent enforcement power. It would leave the court looking impotent, irrelevant, and politically subservient, a devastating blow from which its prestige and authority might never fully recover. Conversely, if the court were to refuse to issue the writ of mandamus, effectively allowing Marbury's seemingly legitimate legal claim to be ignored and his appointment nullified by executive fiat, it would appear to many observers, particularly Federalists, that the judiciary was cravenly bowing to political pressure from the executive branch, thereby surrendering its independence and its role as an impartial arbiter of the law. This outcome, too, would severely damage the court's already fragile authority and its aspiration to be seen as a co-equal branch of government. Marshall, a staunch Federalist deeply committed to strengthening the power and influence of the national government, and particularly that of the federal judiciary as envisioned by the Constitution, needed to find a path, a legal and political strategy that would allow him to navigate this treacherous political landscape. He had to uphold the principles of the rule of law, and, if at all possible, assert the Supreme Court's significance and unique constitutional role, all without triggering a direct, public, and almost certainly losing confrontation with the popular and determined President Jefferson. The unanimous decision in Marbury v. Madison, delivered by Chief Justice Marshall on behalf of the court on February 24, 1803, was nothing short of a masterstroke, a stunning display of subtle legal reasoning, profound constitutional interpretation, and astute political strategy. Marshall ingeniously structured his lengthy and meticulously crafted opinion around three key, logically sequential questions. First, did William Marbury have a legal right to the commission he demanded? Marshall's answer to this initial query was an unequivocal and resounding yes. He reasoned, with compelling logic, that once President Adams had properly signed the commission appointing Marbury, and once the Secretary of State, Marshall himself, in his previous role, had affixed the Great Seal of the United States to that document, the appointment was legally complete and Marbury's right to the office had fully vested. The subsequent physical delivery of the paper commission, Marshall argued, was merely a customary formality, a ministerial act that could not undo the legality of the appointment itself. By withholding the commission, Marshall implied the Jefferson administration was indeed infringing upon Marbury's established legal right. Second, Marshall posed, if Marbury had such a right, and that right had indeed been violated by the government's refusal to deliver the commission, did the laws of his country afford him a legal remedy? Again, Marshall affirmed, powerfully and unequivocally, yes. Drawing upon long-established English common law principles famously articulated by Blackstone, he asserted that the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. For every established legal right that is violated, Marshall contended, there must be a corresponding legal remedy available through the courts. The government itself, he implied, was not above the law. This led inexorably to the third, and by far the most crucial and strategically significant, question. If the laws did indeed afford Marbury a remedy, was that remedy a writ of mandamus issuing directly from the Supreme Court in this specific instance, as Marbury's lawyers had requested? It was here, in crafting his answer to this final, pivotal question, that John Marshall executed his most brilliant and enduring maneuver. His answer, which must have come as a considerable surprise to many observers at the time, was no. The Supreme Court, he declared with careful deliberation, could not issue the writ of mandamus as Marbury had petitioned. Why this sudden and seemingly contradictory refusal, after so forcefully affirming Marbury's legal right to the commission and the general appropriateness of a writ of mandamus as a remedy? Marshall's genius, and the lasting legacy of Marbury v. Madison, lay in the intricate and groundbreaking reasoning he employed. He argued that while a writ of mandamus might indeed be the correct legal tool for Marbury's situation, the Supreme Court lacked the constitutional authority to issue it as a matter of original jurisdiction in this particular type of case. William Marbury had brought his suit directly to the Supreme Court, bypassing any lower courts, explicitly basing his action on a specific provision within Section 13 of the Judiciary Act of 1789. This earlier piece of legislation, passed by the very first United States Congress, contained language that appeared, on its face, to grant the Supreme Court the power to issue such writs of mandamus directly to public officials as part of its original jurisdiction. However, Marshall, in a meticulous and unprecedented exercise of judicial interpretation, carefully compared this legislative provision of the Judiciary Act of 1789 with the explicit text of Article 3 of the United States Constitution. Article 3 clearly and specifically defines the Supreme Court's original jurisdiction, that is, the limited categories of cases that the court can hear directly, for the first time, and its much broader appellate jurisdiction. Cases that it can hear only on appeal from the decisions of lower federal or state courts. Marshall found, critically, that the power to issue writs of mandamus to public officials in cases like Marbury's was not among the categories of original jurisdiction granted to the Supreme Court by the Constitution itself. He concluded, therefore, that Congress, through the Judiciary Act of 1789, had unconstitutionally attempted to expand the Supreme Court's original jurisdiction beyond what was constitutionally delineated by the framers in Article 3. In this, Marshall declared with historic force, Congress, as a legislative body, could not legitimately do, for the Constitution stood as the supreme law. In a powerful and enduring assertion of judicial authority, Marshall proclaimed that the Constitution is the supreme, fundamental, and paramount law of the land. Any legislative act passed by Congress that is contrary to, or in conflict with, the Constitution is therefore void and without legal effect. And then came the historic, oft-quoted pronouncement, the very bedrock of American constitutional law and the principle of judicial review. It is emphatically the province and duty of the judicial department to say what the law is. If a law passed by Congress conflicts with the Constitution, Marshall argued with irrefutable logic, it is the solemn duty of the courts, and ultimately, by implication, the Supreme Court as the final arbiter, to interpret both the law and the Constitution, and, where conflict exists, to give unwavering effect to the Constitution, thereby nullifying the unconstitutional law. The immediate, Practical outcome for William Marbury was that he did not get his commission delivered via the Supreme Court's order. In this narrow, political sense, the Jefferson administration won the immediate skirmish. Secretary Madison would not be compelled by the court to deliver the disputed document. But the long-term, institutional outcome was a monumental, transformative victory for the Supreme Court and for John Marshall's enduring vision of a strong, independent, and co-equal federal judiciary. By strategically, and some might say brilliantly, sacrificing the relatively minor political issue of Marbury's commission, Marshall had ingeniously avoided a direct, public, and almost certainly losing confrontation with the powerful executive branch. Simultaneously, and with far greater historical consequence, he had seized for the Supreme Court a far greater, more profound, and previously unasserted power. The power of judicial review, the ultimate authority to interpret the Constitution and to invalidate acts of Congress that it deemed to be in violation of that supreme document. He had masterfully turned a moment of potential institutional weakness and political peril into a foundational, defining assertion of judicial power that would shape American governance for all time. The principle so powerfully established in Marbury v. Madison, the doctrine of judicial review, is, remarkably, nowhere explicitly spelled out in the text of the U.S. Constitution itself. Yet, through Marshall's compelling articulation, it has become one of the most fundamental, defining, and indispensable features of the American system of constitutional government. In its essence, judicial review is the authority vested in the federal courts, and ultimately and most significantly in the United States Supreme Court, to examine actions taken by the legislative branch, that is, laws passed by Congress and, by extension, state legislatures, and the executive branch, actions of the president and federal and state executive agencies, and to determine whether those actions are consistent with the provisions and principles of the U.S. Constitution. If the court, after careful deliberation and interpretation, finds a law or an executive action to be in conflict with the Constitution, it possesses the power to declare that law or action unconstitutional and therefore void, without legal force, and unenforceable. The profound significance of judicial review in the American political and legal system cannot possibly be overstated. It elevated the Supreme Court from what Alexander Hamilton and Federalists No. 78 had somewhat dismissively, or perhaps strategically, called the least dangerous branch of government, possessing no influence over either the sword or the purse, to a truly co-equal, and in some respects, uniquely powerful branch, capable of providing a crucial check on the authority and potential overreach of both Congress and the President. It effectively transformed the Constitution from a mere statement of broad principles and aspirations into a living, dynamic, and enforceable legal document, whose meaning is continuously interpreted, applied, and given practical effect by the judiciary in the context of real-world disputes and evolving societal conditions. This awesome power has allowed the Supreme Court to play a pivotal, often controversial, but undeniably central role in shaping the course of American history, addressing and often resolving or attempting to resolve some of the nation's most profound and divisive social, political, and economic issues over more than 2 centuries. Over those centuries, the Supreme Court has wielded the formidable power of judicial review in countless landmark cases, with consequences that have rippled through every facet of American life. In the momentous decision of Brown v. Board of Education of Topeka in 1954, the court unanimously declared state-sponsored segregation in public schools unconstitutional, striking down the pernicious separate but equal doctrine established nearly 60 years earlier in Plessy v. Ferguson, and thereby launching the modern civil rights movement. In Miranda v. Arizona in 1966, the court established that criminal suspects must be informed of their constitutional rights, including the right to remain silent and the right to an attorney, before being subjected to custodial interrogation, fundamentally altering police procedures across the nation. Landmark decisions concerning the scope of freedom of speech and religion, the rights of the accused, the legality of voting rights legislation, the parameters of campaign finance, the extent of federal power versus states' rights, and deeply personal matters such as reproductive rights have all been profoundly shaped, and often contentiously debated, through the court's exercise of judicial review. Each such decision impacts the lives of all Americans and continually redefines the boundaries of governmental power and individual liberty. However, the immense power of judicial review, from its very inception in Marbury v. Madison to the present day, has not been without its persistent critics or its recurring, often heated, controversies. Foundational questions have always been raised, and continue to be debated, about its inherent democratic legitimacy. Specifically, should a small, unelected group of 9 life-tenured justices possess the ultimate authority to overturn laws passed by the people's directly elected representatives in Congress or state legislatures? This fundamental tension between judicial power and democratic accountability has fueled ongoing, often passionate, debates about the appropriate role of the judiciary. These debates frequently center on accusations of judicial activism, where critics, often those disagreeing with the outcome of a particular decision, accuse the court of overstepping its constitutional bounds and effectively legislating from the bench by imposing its own policy preferences, versus calls for judicial restraint. The contrasting idea that judges should exercise their power sparingly and defer to the will of the elected branches unless a law is clearly and unambiguously unconstitutional. Furthermore, intense and sophisticated disagreements persist among legal scholars, judges, and the public at large over the proper methodology of constitutional interpretation. Should judges adhere strictly to the original intent or original public meaning of the framers of the Constitution, or should the Constitution be viewed as a living document, whose broad principles can and should be adapted through interpretation to address the evolving challenges, values, and understandings of contemporary society? These are not merely abstract academic debates. They go to the very heart of how American democracy functions, how its most fundamental laws are understood and applied, and how the delicate balance of power is maintained. Marbury versus Madison Star. It began, as we have seen, as a seemingly minor, almost petty, political squabble, born from the intense partisan rancor of a newly changing presidential administration and the personal frustration of a man, William Marbury, denied a relatively low-level judicial post. Yet, from these unpromising and politically charged origins, under the astute, patient, and visionary leadership of Chief Justice John Marshall, emerged one of the most foundational, enduring, and consequential principles of American constitutional law. It was a case where the immediate litigants, William Marbury and James Madison, and the specific issue of an undelivered commission, became almost secondary figures, overshadowed by the larger institutional drama unfolding and the profound constitutional principle being forged. John Marshall, through a breathtaking, almost unparalleled display of legal acumen, subtle political maneuvering, and profound constitutional insight, transformed a moment of potential crisis and institutional weakness for the judiciary into its most defining and empowering achievement. By cleverly, and some might argue, audaciously, sidestepping a direct, and almost certainly losing, confrontation with the powerful executive branch over the specific issue of Marbury's commission, he simultaneously, and with far greater historical consequence, seized upon and articulated a far greater prize for the Supreme Court, the implicit, yet profoundly impactful and institutionally transformative power of judicial review. He established, with a force and clarity that would resonate through centuries of American legal and political development, the Supreme Court's ultimate authority to interpret the Constitution and to declare acts of the coordinate branches of government, specifically acts of Congress in this instance, null and void if found to be in irreconcilable conflict with that supreme and fundamental law of the land. This single, seminal decision, Marbury v. Madison, cemented John Marshall's place as arguably the most influential, most transformative, and most important Chief Justice in the entire history of the United States. His long and distinguished tenure on the court, spanning over 3 decades, would see numerous other landmark rulings that further shaped the contours of American federalism, vigorously upheld the sanctity of contracts, broadly interpreted Congress's power to regulate interstate commerce, and consistently bolstered the power and influence of the national government relative to the states. But it was his masterful opinion in Marbury v. Madison that laid the unshakable cornerstone for the judiciary's role as a truly co-equal, independent, and indispensable branch of the American government, a true and ultimate guardian of the Constitution. The power of judicial review, born from this pivotal 1803 ruling, remains a fundamental, defining, and often fiercely debated pillar of the American system of constitutional government today. It is the primary legal mechanism through which the Constitution remains not merely a historical document, but a vital, dynamic, and evolving force in American life, continually interpreted and applied by the courts to new and unforeseen challenges, complex societal changes, and evolving understandings of liberty and justice. While controversies will undoubtedly persist regarding its proper application, the appropriate scope of judicial power, and the philosophical underpinnings of constitutional interpretation, its central and indispensable role in maintaining the rule of law, protecting individual rights and liberties against governmental overreach, and ensuring that even the most powerful governmental bodies remain ultimately subject to constitutional limits is undeniable. Marbury v. Madison stands as a remarkable and enduring testament to how seemingly small, almost incidental, legal battles, when adjudicated with profound wisdom, strategic foresight, and a deep understanding of constitutional principles, can have profound, far-reaching, and lasting consequences for the very structure of power, the evolving meaning of a nation's founding document, and the ceaseless, ongoing quest for what John Adams so eloquently termed a government of laws and not of men. It transformed the Supreme Court from what many at the time considered the least dangerous branch into a formidable, respected, and crucial arbiter of American law and a key, often central, player in the ongoing, ever-unfolding drama of American democracy. If you like this, please like, subscribe, share, comment for more of this. Bye, History Lover.